All right, welcome back, everybody. We will continue our meeting where we left off, which is item 610, our 1:30 p.m. public hearing. Consideration of A, Appeal AB 23-03 of Planning Commission's decision to revoke a major use permit UP 19-15 for Legendary Farms at 2290 Soda Bay Road, Lakeport, APN number 008 010-29 for high-severity violations and deem Justin Smith and Melissa Smith, let me repeat that, and Melissa Smith responsible persons, and B, appeals AB 23-02, Roberto Estrada, and AB 2304, Michael Wegner, of the Planning Commission's decision to deem these persons as responsible persons for the high-severity violations at Legendary Farms, UP 19-15. So there's going to be a little bit of a process in this public hearing. First, we're going to do the swearing in and the oath. After that, we'll go ahead and hear from CDD and their presentation. And after that, I have, I believe, two presentations from, I don't know if it's separate appellants or if it's the same that will be speaking, but I have two presentations, but that's the order that will go. And first, if we can start with whoever is planning to provide testimony, both online and in the chamber. If you are in the chamber, which I'm not seeing anything because we're sharing the screen, so let me figure this out here real quick. There it is. I can see the attendees. If you are an attendee, please raise your hand, or if you're actually on the panelist, raise your hand if you're planning to speak on this item. Everyone else, please stand up and follow directions from Ms. Purdy.
Please raise your right hand. Do you solemnly swear that the testimony you are about to give before this board will be the truth, the whole truth, and nothing but the truth? I do. Thank you.
Okay. Thank you very much. And as I stated, we will go ahead and begin with the presentation from Community Development.
Thank you. Mireya Turner, Community Development Director. The item you have before you this afternoon is a collection of appeals on a Planning Commission decision to do two different things. One was to revoke use permit 19-15 for Legendary Farms outdoor cultivation, and secondly, deem a number of persons responsible for high severity violations taking place on the parcel. On August 28th, 2023, the Planning Commission unanimously approved both the revocation and determining multiple responsible persons. Since that date, additional internal review has gone on regarding our notification process. In case the board isn't aware, this was the first revocation project we've ever done. So even though it's been in Article 60 for a very long time. During that internal review, we did note a gap between our existing processes of notifications, which are regulated by the state government code, and this new aspect of responsible persons designation or determination. Since that date, we have made internal process changes to close that gap for future proceedings. However, as a result of this internal review, I am actually today reversing the department or my recommendation regarding naming responsible persons of high severity violations. The new recommendations, which will be on a subsequent slide, include upholding Appeal AB 23-02 and 23-04. 23-02 names Roberto Estrada as responsible persons. 23-04 determined Michael Wegner as a responsible person or as an appeal of that decision for high severity violations. Furthermore, my new recommendation is to uphold a portion or in part of Appeal AB 23-03, the segment of that appeal that includes naming Justin Smith and Melissa Smith as responsible persons for high severity violations. Article 60 in our zoning code allows for the revocation of a use permit based on three possible reasons. The first is that this permit was obtained by fraud. The second is that one or more of the terms or conditions upon which such permit was granted has been violated. And the third is that the use for which the permit was granted is so conducted as to be detrimental to the public health, safety, or welfare, or as to be a nuisance. It is my position that although I have reversed recommendations regarding high-severity violations, there is still ample material to continue my recommendation to revoke Major Use Permit 19-15. And so I will proceed with a focus on that. This is the Legendary Farms parcel, an overview. It is, well, you'll see it's approximately 41 acres, virtually flat. On the left-hand side, you'll see the slope overlay on that GIS layer that shows that the sloping is towards that water course on the western side. On the right-hand side, you'll see the approved Legendary Farms cultivation site at the bottom and the unpermitted cannabis cultivation site that's on the northeast corner. This parcel also contains the Rancho de la Fuente Event Center, and the flatlands have historically been used for cultivation of hay. Major Use Permit 19-15 included one Type A3 license for outdoor cultivation, that is up to 1 acre of outdoor cultivation canopy, as well as recognizing the requirement to transfer to mixed light cultivation within 2 years due to the Farmland Protection Zone, or no later than May 21st, 2023. This conversion has not taken place yet. This is the site plan that was approved. You'll note the large green area, that's our 1 acre of approved outdoor cultivation. Secondly, I'd like to just point out that yellow structure at the sort of southeast part that's identified as ag building. Oops, one moment. On September 14th, 2022, code enforcement and planning staff performed their annual compliance monitoring site visit. The staff did meet Melissa Smith, permittee, and Michael Wegner at that site. When staff arrived at the approved cultivation site, they noticed a second fenced area across the field approximately 800 feet away. They requested that access to this second area. Ms. Smith immediately left the group, and Mr. Wegner escorted the team to this other spot. Staff found approximately 3,300 additional cannabis plants in cultivation. They also noted that the cultivation methods were very, very similar to the labeling, placement, grow methods of those in the approved area. Staff also, on the previous day, on that first day, which September 14th, 2022, observed 2 buildings that had been built without permits. These were large metal buildings, as you can see in this slide. They did request access to those structures, but access was denied to them that day. Code enforcement, planning, and law enforcement staff did another site visit the next day on September 15th. At that time, law enforcement staff requested access to the 2 structures, and access was granted. Again, Mr. Wegner escorted the staff that was visiting the site. Also on that day, staff did deliver the notice of violation, and the notice of nuisance and order to abate for the unpermitted cannabis cultivation. So for these structures, 2 applications for ag-exempt building permits were submitted. One was submitted by a prior property owner, Mr. Frank Perez, for the purpose of storage of hay, walnuts, and tractors. This permit was approved, but when it was approved, the site plan showed that the structure was actually going to be closer towards the approved cultivation site, not in the location where we did find it. A second permit or application for an ag-exempt structure was submitted by Melissa Smith with the same use proposed. That permit for that second structure remains ready to issue, but has not been picked up or issued. And neither of those permit locations were where they were found during the site visit. Ag-exempt structures per our code allow for it's a reduced level of scrutiny of a building permit, and it's allowed in times of commercial agricultural uses on a parcel, specifically for the storage of tools, appliances, supplies. You can keep your livestock in there, things like that. It is not meant for a place of employment or activity, extended activity, and it does not allow for electrical or water. However, it is possible to get electrical and water installed with building permits for those in particular. As staff observed in both structures, they saw irrigation systems, oscillating fans mounted to the walls, grow lights mounted to the ceiling, an air conditioning unit, propane tank, air exhaust systems, multiple extension cords, and dried cannabis vegetative waste on the floor. Additionally, they observed ropes strung throughout the interior of both buildings, sticker labels with cannabis strain names, stacks of black and yellow totes, industrial fans, a refrigerator, a wall-mounted flat screen, number of hoses. There are no electrical or water permits issued for either of these structures. During the site visit, staff also observed electrical extension cords going from the 2 unpermitted structures through and then across a property line to a neighboring parcel. Again, major use permit 19-15, approved for 1 acre of outdoor cultivation. Additionally, it also had a type 13 self-distribution. That part doesn't have any play in what was observed today. Activity observed but not approved include unpermitted cultivation in excess of approved conditions, unpermitted structures used in cannabis operation, not part of the permit, and the applications submitted for them listed use that was consistent with an ag-exempt building permit, including the storage of hay, walnuts, and tractors. Additionally observed unpermitted was unpermitted electrical. Also observed in subsequent inspection was a lack of conversion to mixed light greenhouses, which is included in the conditions of approval on A20, recognizing the farmland protection zone requirements. Article 60 allows for the revocation of a use permit for violation of terms or conditions of the approved permit. And just to be clear also, standard in all of our conditions of approval do state that the business activity approved must comply with the approved site plan, the approved conditions, the approved project description. So it is very clear that future business activity is limited to what is approved by the Planning Commission, and any further amendments to that use permit would probably, most likely, most often, require a modification to that use permit, which does go through environmental review and consideration by the Planning Commission. I don't usually use a lot of words in my slides, but I wanted to make sure that you have this before you. These are the amended recommendations, which are different from your staff report. The first one and the second one are both, as I mentioned on the first slide, to grant the appeals 23-02 and 23-04 of the Planning Commission's decision to determine Roberto Estrada and Michael Wagner as responsible persons. Third, granting in part the appeal of the Planning Commission's decision to determine Justin Smith and Melissa Smith as responsible persons, but also to deny in part the appeal that deals with the Planning Commission's decision to revoke major use permit UP 19-15. Then just to make that real clear is number 4, denying the appeal of the Planning Commission's revocation of the major use permit UP 19-15, and then finally, directing staff to prepare findings of fact for the board's consideration at a future meeting. That concludes my presentation. I'm happy to take any questions.
Are there any questions for community development, or do we want to hold until we have all presentations?
We can proceed, but I'd like a hard copy of that screen if we could toward the end.
I think we're going to ask to pop it back up when we get towards the end,
Certainly, I'd be happy to.
just to help us with some of the guidance depending on the decisions we make.
You can have my copy in the meantime.
Okay. So that was our presentation from Community Development. I have 2 presentations. One starts with the County Courthouse, and it says Appeal AB 23-03. The other, and it's a PDF. The other one is an actual PowerPoint presentation. I just kind of want to ask to make sure to provide the right process. Which one goes first?
Can I just clarify real quick? Sorry. Colleen Perkins on behalf of Roberto Estrada. Is it a clear direction that he's being dismissed from being found as a responsible party for the high severity violation?
That is the recommendation. At this moment in time, the board has not made that decision at this moment.
Understood.
Joe Rogway here on behalf of
If you can speak in the microphone, please, sir.
Joe Rogway here on behalf of Mr. and Mrs. Smith, as well as Legendary and United. Just have a clarification as to what is happening right now in terms of what are we proceeding under, what code section. It sounds like from hearing community development that this is not proceeding by way of the high severity violation process, and that I'm confused by that, and I would like some clarification as to what we're doing, and also, is there going to be an ultimate finding here by the board today, because there was reference in the slide to a future findings, a future date where there'd be findings of fact and things of that nature.
So in Lake County's process, after a decision is made, there's 45 days, I believe, and actually I'm going to ask County Council to describe that process where we end up finalizing the findings.
Yeah, so generally there is an intended decision by your board that your board may make a motion on upon making a determination. Then there's that 45-day period by which pursuant to the direction of staff will then submit a draft findings and final decision for your board's consideration at a subsequent meeting within that 45-day period.
And I hope that clarifies that part. And as far as the amendment that has been made to the recommendations from CDD, again, the board has not made that final decision. And I understand kind of what you're asking. Are you supposed to provide us some information based on the high severity and persons of interest, or just the revocation? And in order to not waste time, I appreciate the question. So I am going to go back to the board and just have a brief discussion on if we are willing to only listen to the revocation process and take staff's recommendation, or open for the full breadth of what was brought to us in the first place prior to the amendments, and looking for.
Well, to council's question, I think what you're asking is whether we're going under the HSV, and it sounds like staff recommendation is no. It sounds like they do want to proceed with the
Revocation?
A revocation on the use permit 19-15, and it sounds like that would be under the alternate adjudication per Lake County Code Chapter 21-60, the more standard garden variety revocation. Does that give the clarity you need?
It does. I appreciate that. I have a couple of follow-up questions that are based on this issue. One is, obviously, there are different processes when describing, to your point, Supervisor, there's different processes with respect to high-severity violation versus a normal violation. We have already gotten to this part of the process. There was, if the board recalls, the last hearing was continued to today's date because there were legal arguments that were presented. Since then, Supervisor Spatier did request counsel to meet and confer about the legal issues prior to today's date. Despite my request to do so, there was no response from county counsel. So I don't know from county counsel what the position of the county is from a legal, procedural, and substantive standpoint. And so there's that piece of it. And I would like to have some clarification as to what happened with respect to CDD to change the posture of this case, because this isn't just a change in the recommendation. This is a change in both the process of it and the substance of it. And it's important that a record be made of exactly what occurred and why we're in this posture. One last piece of it is that if we are moving forward by way of a normal revocation under Article 60, as opposed to moving forward by way of a Chapter 13 high-severity violation, my request should be for the high-severity violation to bifurcate this process, meaning to have the high-severity violation dismissed first, so that then when we're presenting, we're only presenting with respect to Article 60, because I'm concerned that there's going to be conflation of legal issues because it's not clear what we're proceeding under, that the other high-severity violation process has been concluded, and we're not going to have that happen, and that's been essentially dismissed, and then have a clean, essentially new bifurcated part of the process here with the board of essentially a normal violation. I think that this clarification is really important given the significant legal issues that we're addressing today.
All right. If you can hold for a sec, obviously I need to check in with county counsel, but I do want to get a consensus of, does the board wish to listen to the entirety of this appeal as it was presented originally, or do we agree with the recommendations to dismiss the appeals for persons of interest, persons responsible, deemed responsible, and also the high severity? Just kind of want to check in because I think that helps out with responding to the latter part of what's left over to discuss.
What is the reason for the change in the recommendation?
Thank you. So as I stated on my first slide, after the Planning Commission unanimously approved both the revocation and the deeming of multiple persons as responsible persons for the high severity violation, additional internal review took place, which identified a notification gap between what we have done with our normal process regulated by the government code as far as notifying property owners and notifying it both by mail and through the newspaper. We had not considered, or I inadvertently overlooked the direct notification of anyone who might be deemed responsible. So it is out of an abundance of caution that staff is recommending that we set aside those recommendations, or the board not uphold my previous recommendations to support finding those people responsible persons. In the meantime, we have updated and improved our notification process so that this will not happen again in the future. But again, this was the first revocation process we have done. First time we've done responsible persons. And so admittedly, our internal notification systems lagged slightly behind where it should have been to be optimal to support those previous recommendations. It is a result of that my recommendations for Appeal AB 2302 and AB 2304 have changed, as well as partially changed for AB 23-03.
And I'll just, I guess, help out and say I'm in favor of the recommendation changes so that we only look at the revocation of the permit appeal and not the persons deemed responsible or high severity nuisance or whatever the case is. Supervisor Green.
Yeah, I appreciate. I think it's an interesting recommendation because if we do adopt it, we would follow up with findings of fact that would be adopted as a subsequent thing. Sounds like the findings of fact here revolve around noticing more than the ordinance itself, and we haven't heard from the appellants yet. I assume they won't look a gift horse in the mouth, but one of the claims raised by counsel here is that the whole planning commission hearing was held improperly. So if we uphold the appeal based on a hearing that was held improperly, I think the findings of fact will get super interesting. That said, I would like to hear from the appellants in 2302 and 2304 at some appropriate time to see if they're okay with the recommendation. And that may be the low-hanging fruit. As to the main appeal before us today, 23-03, I don't want to argue on behalf of council, but they clearly came loaded for bear on the high severity violations. If there is a need or some practical benefit to a smallish continuance so that that particular appeal can come back after we grant the appeal in part and do whatever findings we need to do that, but I don't know if that's possible. I don't know if we can bifurcate that and do a partial grant of the appeal today, but come back another day for the rest of the meat and potatoes.
Supervisors, if I may clarify some.
Please.
On the Chapter 13, which is nuisance ordinance, and Chapter 21, which is the zoning ordinance. And what you have in front of you today are issues, one from each chapter. They have different purposes, and they have different penalties, and they have a different effect all around. They are not dependent on each other. So for a revocation of a permit, you do not need to have a high severity violation, and for a high severity violation, you do not necessarily, it doesn't necessarily lead to the revocation of a permit. They are not interchanged in that way, although a high severity violation could support as evidence for a revocation of a permit. I think what the issue here is that Mr. Rogway brought up was that the process for each of these chapters, for these sections of these chapters, is very different. So for Chapter 13, for a high severity violation and a nuisance violation, high severity nuisance violation, there is a notice requirement which was met for not everybody, but for some of the parties, and it was met through a posting and a mailing. But not everybody is attached to the property, and a high severity violation relates to the individuals who are acting and not the property itself, whereas a use permit relates to the property itself. It attaches to the property and it runs with the land. So in the case of a high severity violation, there were parties that may not have been noticed appropriately, so they would not have been aware of the next step in the process for high severity violations, which would have been the option to appeal. And the appeal would immediately have brought them before your board. It would not have gone to the Planning Commission. It would have come to you. There is no record of a complete application for an appeal to Planning Commission. That requires both a written, usually on planning's, the department's form, as well as the paying of a fee or a fine, the fines that were levied, whichever is less. And both of those have to occur for an appeal to be effective. In this case, there was a notice received, but not the fee. And the position would be that if the people had been noticed correctly, if those who were being charged with high severity violations were noticed correctly, they would have had the opportunity to appeal, come before your board, and have that heard then. And then staff could have used that decision to support the revocation that comes later under Chapter 21. Part of that hearing that would have come before you would have allowed for calling of witnesses and cross-examination and some more complex procedure that you otherwise engage in for your hearings. Under Chapter 21, which is the permit revocation, it deals with the permit, the use permitted on the property, and the permit that runs with the land. So it is not attached to an individual per se. It may impact individuals like the property owner and the uses that that a cultivator could put to the property and whether or not they could continue the approved use. But it wouldn't affect them as directly as a high severity violation, because a high severity violation penalty could include up to a banning of engaging in cannabis cultivation in the county or cannabis activity in the county forever, which is a penalty that attaches to the individual. Whereas with the revocation, the penalty is obviously revocation of the permit, which means that that particular permit, that particular property is no longer approved for that use. So they would have to go through, whomever wanted to do that use again in the future would have to engage in that again, the process of applying for a permit. And the hearing process for that would be more aligned with your usual practice for hearings. It doesn't allow for the calling of, that all parties can call witnesses and that all parties can cross-examine. So I think that was the concern, was if you move forward with both together, it's unclear which process you're using. If you were going to consider the high severity violations, you would have to use the high severity violation process, and if you were when you're considering the revocation, you would have to use the revocation process. Did I make it more muddled, or was it?
To be very clear, September 28th, 2023, Planning Commission, that hearing proceeded under the high severity violation ordinance. It didn't go to the alternative procedures, correct?
Correct. It did not follow. It did not go to, the Planning Commission should not have had that. That wasn't a question that should have been before them that day. It was the high severity violations were considered waived at that point, and they would have been, the challenge of them would have been considered waived at that point because there were no appeals filed. And so it was used as a support for the revocation in the Planning Commission. There was some confusion, however, in the language and as it was presented to the Planning Commission. But if notice had been effective for the high severity violations, if everybody had been noticed correctly, all the parties that were considered violators, then they would have had the opportunity to appeal to the board, request an appeal to the board, and if they had not, we could have considered that waived. However, in further investigation, community development determined that notice was not effective to everybody and is now recommending that the high severity violation determination be rescinded.
So with all that, are we able to move forward today with what is on our agenda? I was very adamant that I wanted this to come back on this date, but a part of me will, I guess, let me ask two other questions before I make my statement. There was a statement that, yes, we did give direction to meet with staff to ensure they knew the process, and it sounds like maybe that process was kind of fine-tuned and decided upon recently rather than 2 weeks ago or a month ago. Am I correct on that? Were they told that today they should be prepared for what you're just describing, that we're going to have to separate it, or else, because you come prepared either for witnesses and cross-examinations, or you come prepared for the other? Just kind of curious what the process was between their counsel and our staff to ensure that everybody came prepared today.
I can't speak to a meeting. I did not engage in a meeting related to policy or process for today's hearing.
Okay, and no such meeting occurred?
I did not.
I'm asking the whole, not just...
No, I did not meet with them either.
And was there a receipt of communication to meet? Whether a phone call, whether an email?
We've received a number of email communications, mostly requests for ERAs. However, there was also a request to discuss the merits of the case, which was actually not what we were supposed to have discussed, but I did not schedule a meeting since the last one. The board told us to schedule a meeting to discuss the process of an appeal, and I did not schedule one, sorry.
And I can clarify just very quickly. I sent a number of formal letterhead letters to both Director Turner as well as to County Council. No response to any of it. So the day of the last hearing, immediately following that, I sent a letter, no response, excuse me, 2 other times. Excuse me, I sent on the subsequent weeks additional letters to both Director Turner and County Council, have never responded to me, and this is all news to me. Of course, I'm welcoming dismissal of the high severity violation piece of it, but there's been no communication. And I've just been trying to ascertain what the process is to figure out what we're doing here. The issues that are causing the high severity violation to be dismissed are the issues that I raised, that the county through Director Turner, through County Council, basically has not acknowledged the entire time.
And I'm going to pause you.
Yeah.
And I don't mean to be rude, because I'd like you to speak on the behalf of why you're here, not to help us through the process. I know that you all reached out. I don't think I was the only one you reached out to. Sorry, I denied any communication with you. I responded with a no. But I know that I received some communication from one of the team members that represents somebody. I want to make sure that this is a fair playing field for everybody to be prepared for today. I appreciate the amendments. And I'm also kind of confused. I guess I need County Council to help me out in the sense that if the appeal shouldn't have been done at the Planning Commission level, and we're here solely looking at the appeal to the decision, not the appeal at the planning, but the Planning Commission made a decision on something that maybe they weren't supposed to make a decision on, and then here we're appealing that decision, but we're changing that it's no longer based on that decision. It feels very gray. And I'm trying to better understand what is in front of us today, and is it an appeal of what was decided, or is this a new item in front of us?
So just to make, and just to start with a point of clarification, when the term county council is used, there has to be a distinction made between Senior Deputy County Council Nicole Johnson, Deputy County Council Carlos Torres, who's been designated, assigned to represent CDD. County Council Lloyd Gintivano, myself, on the other hand, represents County Board of Supervisors for purposes of this appeal. So,
Thank you for that clarification.
Thank you. And as far as communications go, because again, references were made to County Council, I can represent to your board that I met with Mr. Wegner, one of the appellants here. We discussed procedural questions pursuant to your board's direction. There was a request made by him, reached out to me for a meeting, and we did talk about the procedures that were to take place in this type of hearing. So all of that kind of as an introductory point. To your question as to whether or not this is properly before your board, in essence, right? And Director Turner could certainly speak to this, perhaps Senior Deputy Johnson, Deputy Torres may also speak to this. Your board has the staff memo that was presented to the Planning Commission as well on that September date. There were in that memo itself, it does not, my understanding of it is that it does not exclusively solely deal with just the high severity violation issue under Chapter 13, that it dealt with both the high severity violation, made references to high severity violations, as well as Chapter 21. In this case, it would be Article 60 of the zoning ordinance, which deals with general permit revocations. And it's specifically in that in itself, Article 60, particularly Article 60.12, was specifically referenced on page 13 of that staff memo. This is, again, the staff memo that was presented to the Planning Commission for recommendations in which the Planning Commission acted on. On page 13, the first bullet point as to the Planning Commission's findings speaks to the fact that based on Article 60.12 attached, which is attachment 10 to that memo of the Lake County Zoning Code, a hearing to revoke a use permit may be initiated by request of the planning director. So certainly that was presented by the Planning Commission. Your board may seek clarification as to the nature of this appeal, because from what was filed in the, I'll just call it the appeal, the notice of appeal document, we have 3 separate appeals, 23-03, 23-02, and 23-04. And your board has we're just provided with the amended recommendations by CDD staff as it relates to each of those appeals. Your board may want to seek clarification, particularly on 23-02 and 23-04 for those appellants, respectively. 23-02 is Roberto Estrada is the designated appellant. 23-04 is Michael Wegner as the designated appellant. For those corresponding appeals, your board may want to seek clarification as to whether, given in light of CDD staff's amended recommendations today, whether they are still pursuing an appeal on the permit revocation under Article 60, because each of these appeal documents makes references to both to some degree or so that would be one option for your board in order to somehow streamline this process. But again, going back to your question as to whether or not they're both set of procedures are properly before your board under these respective appeals, part of that would come from what the Planning Commission deliberated on and what the Planning Commission issued as its action coming out of the recommendations made by CDD staff on that September date.
So I would even say that based on what I'm hearing, that we shouldn't even be making a decision on the first 2 if it wasn't even supposed to go to, because right now it's an appeal of the Planning Commission of the high severity, so us making a decision on the appeal of the Planning Commission is not an appropriate action for us to take, since it can't be appealed if it wasn't supposed to go to them in the first place. I'm sorry that I'm learning on the fly here, and
Mr. Chair.
I'll let them.
Oh, my
I'm not the
apologies.
attorney. Go ahead.
Mr. Chair, if I may. So staff's determination in their investigation was that notice was ineffective, which means that even if the Planning Commission had authority to hear this, it would not have been appropriate because the parties who were accused of high-severity violations or alleged to commit high-severity violations did not receive proper notice. So it would have failed in that instance. For those parties that did not receive proper notice. In order, and as Director Turner has said, staff is correcting their forms and how they engage in investigating and responding to high severity violations, so that this disconnect does not occur again between Chapter 21 and Chapter 13. But in this case, that disconnect was there, and so it was unintentional. It was unfortunately brought before the Planning Commission, and the Planning Commission did engage in a decision. Because of that, in an abundance of caution, staff brought it before your board, also in not just that, but also in response to the appeals that were filed, which addressed both issues, so that that can be addressed, put on the record, and clarified. However, in light of staff's determinations as to notice, their recommendation has changed in that it was not effective from the start, and therefore it should be dismissed, largely. And so, but the Planning Commission's decisions were not, they were 2 separate motions, and they were not dependent on each other. So they were asked to consider high-severity violations, yes, and they should not have been considering high-severity violations, correct. And if the high-severity violations, if they had been appropriately considering high-severity violations, that could have been one of the pieces of evidence that would have supported a revocation, potentially. It is not a requirement for revocations. They did not rely solely on that, and they did not need to rely solely on a high-severity violation. They can rely on the violations that staff presented on that day in addition to, or those same violations, even though they were never determined, even if they're never determined to be high-severity violations. Because the Chapter 21, Article 60 does not require that a nuisance violation be found or that an individual be found to be in violation of Chapter 13 in order to have violated Chapter 21. So, so staff presented the report that you have in your packet today, which outlined all of the violations they noticed, and that was what the revocation was based upon at the Planning Commission level, but it was not. And that was an appropriate determination by the Planning Commission because that is their authority. They do have jurisdiction over revocation decisions, and that would properly come before you as an appeal.
As Section 60 or Article 60,
Article 60
provides that Planning Commission and/or the Board of Supervisors.
Correct.
Okay. So I'd like to cross off some things that we don't need to continue to discuss. Obviously, there's recommendations by CDD Director, Director Turner, and looking to see if we're okay with dismissing and I guess upholding the appeal, even though I won't get into that, but upholding the appeal of the persons deemed responsible as suggested by CDD, and looking for.
I need to hear from appellants, even if it's a slam dunk on 2302 and 2304. They have a right to speak on this, if only in support of this. To what you raised, it's apples or oranges. It can't be both. So although I do see on page 13 of the staff report some citations to Article 60 and the procedures therein, I'm assuming the findings of fact based by the motions that are here, all the Planning Commission action was based on high severity. My question for County Council before we get to your question, Chair, is if the appeal was granted in full for AB 2303, would that preclude a subsequent initiation of a more standard permit revocation hearing?
No, your planning, excuse me, my apologies. I'm just surprised I haven't referred to you all as Your Honor yet. Supervisors, your board hears appeals for the Planning Commission under Chapter 21 de novo. So what that means, new, as if it's fresh in front of you. You're not dependent on the Planning Commission's decision. You're not bound by it. You can look at the evidence and weigh it as your body deems fit and make a decision based on the presentation that's given you today. You can also, and included in that evidence is the Planning Commission's determinations or findings or the reports that were presented to them. But it is not determinative of your decision. You do not have to follow that. The Planning Commission may have made reference, the report may have made reference to high severity violations because the violations that were witnessed by staff were determined by staff to be high severity violations, but they do not have to be legally found to be high severity violations to be violations considered by the Planning Commission. So the Planning Commission can still consider those violations, even if...
And I'm sorry, I'm going to disagree. It's not surplus language when you say revocation of major use permit for high severity violations. That's exactly what they got rung up for in September of last year. That's exactly what's on here appeal today. So I get that there's alternative procedures in the code that this could have tracked on. What was brought to the Planning Commission, what they voted on, was a high severity violation case. So to take a partial recommendation to grant the appeal in part and deny in a part relies on one, our willingness as a board to proceed under these procedures for something that is not ripe necessarily for this board to appeal, and some willingness of council to address the more of the Article 60 stuff than the high-severity stuff they've been fighting like hell over the last month plus for.
The high-severity violations relate to the individuals and whether or not they are deemed to be individually responsible for the violations. The violations themselves, absent that, separate from that, can be considered independently as part of a revocation. So it is not necessary for an individual to have been found responsible for a high-severity violation for that violation to be the grounds on which a permit is revoked.
County Council.
So on the minutes coming out of the September 28, 2023 meeting of the Planning Commission, the Planning Commission on motion did make reference to approving the motion to revoke the major use permit, UP 19-15, for Legendary Farms, including a list of responsible persons that were named in those minutes. It does reference 4 high severity, after naming that list, it goes on to say 4 high severity violations, property located 2290 Soda Bay Road, based on the findings in the staff report dated September 28, 2023. So based on that approved motion, it references back to the findings of the staff report in September 28, 2023. Those are located primarily in page 13. The recommendations, recommended findings were submitted by staff, number 1 of which makes specific reference to Article 60.12. That would be the general revocation permit and all the procedures incorporated therein. So number 4 of those recommended findings is contains the language for high severity violations. So for what it's worth, there's also in Chapter 13 itself on the high severity violations, it specifically and expressly provides that it's not the exclusive remedy for any person or any party found to be in violation thereof based on certain activities. Chapter 13 itself expressly states that a high severity violation administrative proceeding, the relief obtained pursuant to that is not the sole remedy that staff, in this case CDD staff, can utilize. So that's what's before your board today. It appears that your board can make, as part of its findings, a determination that that what came out of the Planning Commission hearing actually dealt with both, and due to, apparently as it's laid out in this hearing today, that due to procedural deficiencies in noticing as to the high severity under Chapter 13 and those requirements, that with taking into account the fact that it's not the sole exclusive remedy for pursuing violations here, those deficiencies, that's what led to, it appears, that's what led CDD staff to make these amended recommendations. That does not automatically exclude the Planning Commission's decision under Article 60 to revoke the permit. And that's what's left if your board were to take these recommendations, amended recommendations by staff.
Okay. I want to move forward, taking one item at a time, and then we'll get to the revocation part, because what I'm hearing is we can move forward with that, but I want to also cross off, and I want to bring up the first one, which is...
AB 2302?
Sure, let's start with 2302.
We can take action without public input, or we're good on that?
Well, one option for your board is to Supervisor Green's point, is to perhaps seek clarification from the appellant.
Yeah.
Under AB 2302 to see, because we're dealing with 2 sets of appellate procedures here, if given in light of staff's amended recommendation today, whether they're still willing to proceed with the appeal under the procedures of Article 60. That's the general revocation permit, because under Article 60, any interested party who disagrees with the Planning Commission's decision can make an appeal, can file an appeal. So a clarification, your board can certainly seek that clarification and any additional comments that the appellant may have.
May I please be heard? I have a clarifying question, which is, what are we appealing?
So at this moment, what we're going to do is we're going to take up AB 2302, AB 2304, then we will come back to AB 2303. I want to make sure to open it up for any testimony on 2302 prior to our making any decision. That way we allow comment to be made by those that were sworn in. And we will come back to 2303. And I'd like to open it up for 2302 for whoever wants to testify for that item.
And again, I just need clarification. Excuse my confusion here, but this is all very alarming that it's all done at the last minute without any notice to us prior to today, again, despite our requests for information from the CDD. Are you looking for our full presentation on Roberto Estrada being labeled as a high-severity violator? Because that is the only appeal we filed.
We are, at this moment in time, recommendation is to dismiss it or approve the appeal, grant the appeal. I can't say we haven't all stated that that's what will happen, but do you want to speak on that recommendation only, then for the board to take action on that recommendation? If the board's going to go against that recommendation, then I say the board should not take action and we should listen to a full presentation. But at this moment, that's the recommendation. I want to speak on that recommendation, and if the board moves forward with that recommendation, then that simplifies that appeal, in my opinion.
I would just echo the problems that the community development director laid out with respect to this appeal and the handling of it procedurally. It has been handled very improperly, oftentimes conflating the Chapter 60 with Chapter 13 and the rules that go along with that. As we laid out in the Planning Commission hearing, almost a year ago now, our client never received proper notice at the outset. There was never an NOV, there was never a notice of abatement, there was never proper notice of the Planning Commission hearing, and in fact, there wasn't proper notice of this hearing. We never filed an appeal as to revocation of the major use permit, so I won't speak to that. We have a full several-hour presentation with witness testimony and exhibits that we'd like to present if Mr. Estrada will be considered as a high-severity violator. But based on the current recommendation to the board, I will save those several hours of testimony. My inclination is to make a record on this and present all this evidence so that we can follow up by pointing out all the improprieties. However, I assume you don't want me to call witnesses to the stand at this time and introduce exhibits as to the high severity classification of Mr. Estrada if you're going to be dismissing it.
And if it's not the case, I will make sure that you have a chance to provide your presentation before action by the board.
Okay. I would just state in my experience in handling of this matter is that there's been numerous lies put forth by the community development director. There's been improper proceedings with respect to obtaining discovery. We filed a PRA request probably 45 days ago now that was withheld from us. It was rerouted from the normal person that handles these PRAs to a different person who told our office that they attempted to contact our office, but that we were refusing to pay the $18 for the PRA docs, which is an absolute bold-faced lie. And in fact, as soon as the normal person that handles PRAs contacted our office, within hours, we had the money to them. So there's been withholding of documents. The sheriff's office, I sent a PRA in April. They just today responded with a report from the sheriff's office and said it was an oversight on their part, and they were apologizing, but the fact that the sheriff's report comes up only on the date of the hearing when it was requested back in April seems incredibly suspicious. So there's just been a plethora of mishandling in this case and not following Chapter 13 throughout these proceedings, plus a lack of communication, which I think this could have been handled in a much more compliant manner and a much more proficient manner, and because of this, our client has suffered greatly. He's lost many thousands of dollars trying to defend against this violation that was never even properly noticed at the outset. So on that, I will submit to your recommendation for dismissal.
Thank you very much. Anyone else wish to speak on this, please?
Frank Perez, I don't know if this is proper or not, but I'm sitting here listening to all this, and there's something that was done at the planning department that I seen. One of the planners brought another person in besides Michael and the Mr. Gonzalez or whatever his name is, and he was supposed to be deemed responsible as well, and now his thing has been completely erased off of the minutes. So I don't understand how that can be. You follow what I'm saying?
Yes, but at this moment, we're talking about 2302, and I do want to speak to that a little bit
Well,
later.
what is 2302?
Roberto Estrada.
Just that one person?
At this moment, it is just that one person.
Okay, well, are you going to bring up the person that,
One step at a time.
okay.
Any further comments on this, on 2302 for Roberto Estrada? All right, bringing it back to the board.
Just one quick question. I'm looking at page 13 like we're talking about. Was there approximately 3,340 cannabis plants found outside the approved cannabis area, canopy area?
Yes.
Okay, so, I mean, all of this other stuff aside, there still was something that took place.
Additionally, 2 unpermitted structures where activity that was related to the use permit but not approved.
All right, well, with that, I will go ahead and,
Can I just clarify that the 3,340 plants were not found on Mr. Estrada's property, nor were the 2 ag exempt buildings?
I
Mr.
wasn't, I was talking about the property, I wasn't.
Okay, I thought we were addressing only 23.
No, I just asked a simple question to that.
Sorry.
Yep. So I motion to grant the appeal for 23-0202.
Second.
If I may.
County Council?
Members of the board, yeah, thank you. Just for further clarification for purposes of this motion, and also for the anticipated findings of fact for your board's consideration, your board may move to grant appeal AB 23-02 of the Planning Commission's decision to determine Roberto Estrada as a responsible person for the high-severity violations on property 2290 Soto Bay Road, APN 008-010-29, and direct staff to prepare findings of fact for the board's consideration pursuant to that motion.
So moved.
Second.
Just point of clarification, this is in my district, so I don't want to grab the motion, but I got 2 others going. Would you mind,
Oh, you want the motion?
please?
Okay. I mean, because you've taken our motions before, and I'm just kind of following suit.
Let's just go with it. So moved.
Second.
All right, we have a motion and a second. I hope you kept track of that, Ms. Purdy. And all in favor?
Aye.
Aye. Any opposed? Motion carries. Now we're going to speak on AB 2303. This is regarding, and I'm sorry, I'm lost here. This is regarding Michael Wegner. Anyone wish to speak on, sorry, 2304, thank you for the correction. Anyone wish to speak on this?
Michael Wegner, the appellate. I think I do appreciate the situation or the scenario that we're in. The reality is we've really just kind of started figuring out how all these things play out. And with that, I do want to give each other a little bit of grace as far as we're figuring out the whole industry, okay? With that, I do appreciate the willingness to grant the appeal to not find me as a responsible party. But I would ask if you would consider granting that appeal not based on procedural intricacies, which as noted are extensive issues, but really on the basis of merit and what the code and what the law says in finding or deeming a person as a responsible party. I think that that could be important moving forward or down the line for other people, not necessarily just for myself. And of course, I wouldn't stipulate or require such a thing. I would just, for the record, think that that might be important. With that being said, if you folks had any questions that I could answer or attempt to, I would be willing to answer them.
Supervisor Green, was that a pen up for a question or comment?
Just for this and the previous appeal, procedural defects, let's just call it that. And I appreciate the grace that you're asking for. As far as the finding of facts, could they be important? If the appeal is granted, maybe as reading material, but I don't know that it's substantive. And if there's something wrong with the findings of fact when they come back to this board for approval, I suppose you could haggle them out then, or you could reach out to county council if you want to haggle before that does. But it sounds like you're ready to proceed.
Yes, sir.
Thank you.
Thank you very much for your comment. County Council.
If your board also has the option pursuant to what was discussed before, to obtain confirmation and clarification from the appellant on whether or not, aside from the high severity, appealing the high severity violations determination, whether or not the appellant is still seeking to appeal the general permit revocation decision of the Planning Commission.
Wouldn't that be taking up 2303 rather than 2304?
It would be, there is some reference made in 2304 as to the permit revocation, so it's really more of a confirmation or clarification, just to be sure, on record.
Yeah, on record, I'm appealing my appeal, not relevant to the major use permit.
Okay.
Clarity.
Thank you for that clarification. Any further public comment for 2304? I just need to check in.
Yeah.
I believe you walked in a little late. Have you been sworn in?
No.
I think we need you to be sworn in.
Okay. Thank you.
Just raise your hand. Do you solemnly swear that the testimony you're about to give before this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you for that.
Yeah. My name is Sarah Bodner of Golden State Public Affairs, and I'm a consultant that has moved dozens of projects through this county and neighboring counties. And I'm watching all of this with great interest because I think that we're in new territory. And I understand there have been a lot of complexities to this particular case and even the particular charges. And to the point of this, the current case that you're hearing, I think the request that was made by the appellant is important and could possibly have repercussions for other consultants. So I just wanted to raise the question is, through this process, because it's been a bit muddled, I think it's unclear for myself and other consultants that may operate in this county, what is the basis for being held a responsible party in a case like this? We see noncompliance, we see compliance, both can happen. Do we have clear parameters for what that can look like? Or is that opening up some liability for the county to not have that clearly identified and be able to point to? Thank you.
Thank you very much. Did you want to respond to that, Director Turner?
Yes, Chapter 13, Section 47Q lists out 7 different ways a person could be deemed a responsible person. It includes a person who causes or materially contributes to the causation of an administrative violation, who maintains or allows it to continue, a person whose agent, employee, consultant, or independent contractor causes or materially contributes to the causation of an administrative violation, an on-site manager of a business who is responsible for the activities occurring at the premises where this administrative violation occurs, a trustee or other person who is given the legal authority to manage property on behalf of someone where that administrative violation occurs. It goes on, parent or guardian, a person who is the owner of or exercises control over, or any lessee or sublessee with the current right of possession and control of real property where a property-related administrative violation occurs. That was the list that was used in the Planning Commission staff report.
Okay, thank you for that response. Anybody further for 2304? All right, bringing it back to the board for action.
Turn it to County Council for the form of the motion.
Yes. So the motion would be to grant appeal AB 23-04 of the Planning Commission's decision to determine Michael Wegner as responsible person for the high severity violations on property 2290 Soda Bay Road, APN 008-010-29, and direct staff to prepare findings of fact for board consideration pursuant to that motion.
So moved.
Second.
We have a motion and a second. All in favor?
Aye.
Any opposed? Motion carries. So before I move on to 2303, there were other individuals that were named in the original hearing that occurred at the Planning Commission. They are not appealing, but at the same time, in my mind, the same procedural issues on notification for the Planning Commission occurred for those individuals as it did for those that did appeal here to the Board of Supervisors. Does the same result happen to all those individuals previously listed?
No, not as a result of today's actions, because they're not, as you noted, they did not appeal, and they're not, and those decisions are not before you.
How can they appeal if they weren't notified?
That is true. And if it comes up, well, I'm not sure we have a process for that. If we're recognizing on the record that they were ineffectually noticed, then I suspect that CDD is not going to enforce the high-severity violation determination on those parties. But I would have to look into that.
My only concern is there was an official approval of such at the Planning Commission. Does CDD have the discretion to reverse a decision made by the Planning Commission without bringing back for a rescinding of the decision?
Director Turner would probably say no, although that's been her opinion in the past. I would recommend then, if that is your concern, you can certainly give part of your direction to staff would be to bring those back so that you can take care of them, as far as you have today with those who did appeal.
I think if we are acknowledging a procedural default or fault in our process, that should be provided to all of the names that were on there originally. I know, for full disclosure, one of the names, I was surprised to see their name on there, and they never received any communication about the Planning Commission, didn't even know that they were on the list, and more along the lines of they're not even at the property, don't own the property, so on and so forth. That doesn't mean that they weren't involved, but if the same process took place, in my opinion, it would be best, and looking to the board, to ensure that we provide all those individuals with the same result.
We can certainly look into, you can direct staff to look into whether it would be most appropriate to take the remaining, those others named who have not appealed back to the Planning Commission and have the Planning Commission reconsider their vote, or bring it before your board collectively to.
I would suggest that it was done at the Planning Commission. I would like the Planning Commission to make that final decision. But looking at the rest of the board, if there's agreement to doing so.
I have some information, I apologize, related to a different individual, Mr. Torado.
If you can just hold on. I'm checking in with the board at this moment in time. I recognize that you are there.
I mean, now that we're here, I mean, earlier I was thinking that when the motion states to revoke the major use permit for Legendary Farms, including responsible persons, but it's right there is what it was basically about, was that. And when Council Nicole had mentioned that the other decisions weren't in their purview, I was thinking, well, maybe we have to send it back to Planning Commission to take those out of their purview and readdress the permit, but I don't know. That was my thought, because you're bringing this up now with the other people involved.
It was recommended that it was brought before your board because your board does hear appeals from the Planning Commission. They were, in effect, both decisions from the Planning Commission, both the high-severity violations, and even if the high-severity violations decision was improper and ineffective, and the revocation. The revocation was properly before the Planning Commission, and your board does hear the appeals de novo. So For the revocation, it would be properly as an appeal before you. And we didn't think it would have been a clear record if we were to have requests that you take the high severity back to the Planning Commission for revocation of, or reconsideration of their decision, because it might muddle your record on the on the revocation.
That helps me. I'm willing to do what you're saying.
Is there consensus to?
Yeah. Okay. It's not ripe. It's not ripe for review. I appreciate the concern. It's not before us today. I think the findings of fact that issue from these appeals that are granted certainly will be useful should a permit application come down the road. But I also think it's within the discretion of the CDD director to say, oops, that didn't work out on these appeals, so maybe I won't enforce that. If there's consensus, there's consensus. I just don't think that issue is before us today.
And so I'm going to look at county council representing the board. Those names are on the memo and throughout the information of what occurred at the Planning Commission. We are agreeing to acknowledging an error in our procedure. Can we provide that direction to staff? We're not making a motion, but direction to staff to bring that back to the Planning Commission. Is that within our purview within this item at this moment?
By virtue of the names being referenced specifically on the board memo, on staff memo for this hearing, one option for your board is to direct staff to explore alternative other options on how to address the names of the individuals who have not filed an appeal. So it's not formally before your board, but at the same time, they're still named in the board memo. So the direction of staff would be to look into it further, do some research, further research as to what the ramifications are of having these individuals listed as they are for community development department purposes, and explore other options that may be available in addressing potential issues that might arise from having them on this list.
Which could lead to bringing it back to the Planning
And that could be
Commission.
one of them,
Okay.
yes.
And I'm perfectly fine with that discussion.
Yes.
Okay. And it looks like you have consensus on that. Sir, I'm going to come back to you, but next is 2303. What specific topic do you have in mind?
Thank you. I appreciate it, Supervisor. So before we get to 2303, one of the individuals who was added as a responsible person at the Planning Commission is Mr. Dominic Tirado, who is the person who's responsible for the cultivation with the 3,000 plants. And that's the information that we've been trying to provide we did provide to County Council, to Director Turner in October of 2022. And immediately after there was the inspection. Mr. Tirado was never contacted by the county. This issue came up at the hearing. And I say this because Mr. Tirado has never provided any notice to be at the hearing.
So I'm going to interrupt you. I think that we've given direction to help with that. That doesn't mean that you can't speak to that during the 2303 presentation.
Whatever the preferences of the board, I just wanted to clarify something that the people who were not notified that there was a violation against them were not notified that there was a hearing, were not notified that they're deemed responsible parties, which is
And I believe that we just took care of that. Okay? So we're going to move on to 2303. We already had a presentation from CDD. Again, I have two presentations. You said it didn't matter.
Sorry. I thought I turned them off. I guess I turned them off.
I believe you mentioned it didn't matter in which order to do the presentations.
One presentation was counsel for Mr. Estrada, who has been dismissed. My presentation is one at the courthouse, but before we get to 2303, if there's a motion to dismiss the high severity violation as to these parties, my request is to do so first, because that changes the entirety of what I am doing, what the The process.
That's not in front of us to take action on that. What's in front of us is specifically the names that were named on the agenda, hence why we are asking for the discretion of Director Turner to look into it and possibly bring it back to the board that did take action on those individuals.
I'm referring to my clients, Mr. Smith, Mrs. Smith, Legendary Farms, United Investment. They are 23, they're 03. They are that appeal.
Yeah.
That appeal, the request was at the beginning of today's hearing to have the partial granting of the appeal with respect to the high severity violations. That is before the board. My request is to handle that business first, because then it is a different presentation to the board and different legal issues and different facts that are relevant to those legal issues with respect to a revocation that is pursuing by way of Article 60 rather than a high severity violation that's pursuing by way of Chapter 13. They're not interchangeable. They are not things that were dual tracked at the planning commission.
I will say this. I can't speak for the board, but so far we have taken the recommendation of Director Turner for the amendments. So please present solely to the revocation and not to the high severity violations on that partial, and then we will move on. If there is a position of the board to potentially not go against the recommendation, then I will allow you to also speak to that.
I understand. However, my presentation is entirely geared towards the high severity violations. There was no notice to council, despite me just having a hearing with County Council and Director Turner last week at the Planning Commission and having regular emails. In fact, County Council mentioned not being a part of any of the communications. County Council was CC'd on 2 formal letterhead letters from my office in July and August that we had sent to him. So he did have that. The issue is an issue of just notice as to what's happening at this hearing and notice as to what we're doing here and like what is happening, because even though I understand in good faith that the board, it sounds like, is willing to proceed by way of the recommendation of the director, my request nevertheless is for us to...
I hear your request. I'm going to ask for a 5-minute recess. I'd like to have a conversation. So 10 minutes. Come back at 3:28. All right, welcome back. Thank you. Needed to take some time to discuss some of the options in front of us here. Appreciate Vice Crandall and helping out in that discussion as well. So I'm going to make a request of the board with two options. Things have changed today. We've made some agreements based on some recommendations, and I think that changes kind of the platform for AB 2303, or at least the foundation of it. And so option one is to ensure everybody understands what we are, how we approach this topic by looking at a 3-week, I believe, continuance to September 17th. For the whole 23-03, or B, doing a tentative approval of the recommendations for the persons deemed persons of responsibility, so that at least it can provide for their counsel to best be prepared to come back. But I think that, I'll just be blunt, I've been a little confused and in the clouds here based on the changes that have occurred and the process that we are taking on. And I want to make sure everybody is best prepared and understanding of what, how we approach this item when we come back. And so we had a conversation. We looked at September 17th, 11 a.m. as a potential continuance, and then either A, the whole 23-03, or partial 23-03 by doing a tentative agreement approval of the persons deemed responsible. And County Counsel, Mr. Guintavano, did I miss anything? Would you like to add anything to that?
No, that is correct, and upon depending on the decision of your board, I have prepared motion language to that effect in either scenario, in either option.
Okay. And Vice Chair Crandall, did you need to add anything else?
You got it.
Okay. And just wanted to check in with the rest of the board on your thoughts and potential action.
Well, I'd like to hear from the appellant. You know, if there's some economy to be gained by splitting the appeal in half, and if in fact County Council says we can take partial action while deferring action on the revocation itself, I guess we can do it. I just don't know what the advantage is.
And that's why I put both options in front of you.
And would like to hear from the appellant.
And before that, I just want to check in with the rest of the board so that the appellant knows what to respond to.
So the question is take partial action today and just address the revocation on the 17th?
Or, well, there's three options, obviously. You can say, no, we disagree, we want to continue today. But the options are the whole 23-03 or partial.
On the 17th.
Yes.
Thank you very much. I'm okay pushing it to the 17th.
The entirety of
Yeah.
2303?
Yep.
Okay.
Yeah, no, I'm fine with that.
All right, I will ask the appellant's counsel if that is just a response.
Yeah, yes, thank you. So first, I checked my calendar. I am available on the 17th. Excuse me. So for whatever the board chooses, I will be here. My request, respectfully, would be to bifurcate the process so that we address the high severity violation issue today, and then come back for the remainder on the 17th. That changes my process and my understanding of what the legal issues are enormously. That, you know, there is an entirely different set of legal considerations based on that. One related issue is that whichever way we decide to come back, or the board rather decides to come back on the 17th, I would like to have County Council provide notice to me, to appellant, as to what the issues are that we're actually appealing and what the bases are for raising those issues now. So what I mean by that is, if we look at the memorandum for today, it's all predicated, it's item 6.1, it's all predicated on high severity violations. If we go back to the initial notice of violation, the initial notice of nuisance and abatement, that is all for Chapter 13, notice of violations. And that's what got appealed to the Planning Commission. Look at the Planning Commission's determination. It's all related to the high severity violations. There is no differentiation that occurred during the Planning Commission at the time, in fact, between the Chapter 13 issues and the other purported revocation issues. They're all one thing.
Okay.
But I should say that my preference is to only address the revocation if we need to.
And thank you for sharing that preference, and thank you for also letting us know if you were available. I'm going to make a statement that I agree with my colleague Supervisor Simon of pushing the whole thing and bringing it back, because I agree that we need to look at the entirety of 2303 in order to make sure that we make the right decision, and looking to see if Mr. Guintavano, I need to open it up for public comment on this for those that have already been sworn in for the continuation of,
Yes.
rather than just the appellant's counsel. So I want to open that up for any other comment that we may have on that.
What am I allowed to speak on? Because this is very confusing for me.
You and me both. It's right now it's the continuation of. And so
Just the continuation.
Yes.
There's nothing that I could put on record that was said earlier that I really didn't have a chance to speak on, and it's not the,
Because
what
we
I'm
ha-
talking about the last time I came up here, it's something else.
And I understand that, but we have not taken the entirety, we haven't taken up 23-03. We started with 23-02. And I want to make sure that we don't repeat everything. And so if I,
This is something brand new.
and I, at this moment in time, let's move that to the 17th, please, as that would make it so much easier.
Okay.
Thank you. Any other comment?
May I please have some clarification? Sorry, I have a clarifying question. So we come back on the 17th. Am I presenting the entire high severity violation defense to the board?
Yes, because we are not taking action. If that's the way the board goes at this moment in time, it looks like that will be the direction, that we are not splitting and saying tentative approval of based on the recommendation. We're saying let's keep it whole so that we can have the whole conversation.
Then if that's the case, will we be conducting the hearing pursuant to Chapter 13, which calls for witness testimony under oath, penalty of perjury, burden of proof on the government?
And I'll check in with county council.
The procedures, the short answer to that would be yes, if there is going to be a high-severity administrative appeal hearing before your board. Now, it should be noted that staff, as part of their amended recommendations, has recommended that your board, at the conclusion of this appeal, AB 2303, to grant the appeal in part and deny it in part. The granting in part would be on the high-severity violations issue and those set of procedures. The denial, under staff's, CDD staff's recommendation would be to revoke the major use permit. So that is still on the table. That was placed on the record. That will still carry over to the next hearing. Your board has certainly the discretion, if your board chooses to continue the entirety of AB 2303 to the continuance date, to that later date, certainly your board has the discretion to dictate or outline the presentations or the order thereof of the presentations based on those two issues, and treat it in a way, in a bifurcated fashion, in that manner. It can still be held in a bifurcated fashion on that same day, and your board has discretion on which presentation goes first.
And I don't understand what council's saying. What does that mean?
So basically, we're looking at two separate items, the high severity nuisance and the revocation, and to pick those up separately.
I would object to that. If that's going to be the direction, I'd just rather go today. I mean, I can talk to my client about it, but those things are not differentiated in this entire process. until today, that's going to just double the amount of work I have to do. It adds to the expense of my client, and it doesn't address the fundamental flaws, the legal flaws that the county, that Director Turner and County Council.
I'm gonna pause you. I understand what you're saying, and even though County Council, if I may, please correct me, if it's possible to bifurcate, but there will be some potential blending between the two. So that doesn't mean it has to be physically separated, because I understand that one might lead to arguments of the other. But we are going to make a bifurcated decision based on recommendation of partial and partial. Does that help?
Ultimately, your board will have one set of findings and final decision under Appeal AB 23-03. And that findings and final decision will discuss two issues. One is under Chapter 13, the high severity, and your board's findings that may come out of that. We know that CDD staff has outlined their amended recommendation as it relates to the high severity violations issue. And that same findings of fact will also cover the issue of the permit revocation. The bifurcation, I believe, speaks to the two different sets of procedures that would apply if both were heard by your board with full testimony and presentation of evidence. Under Chapter 13, in a high severity violation, yes, cross-examination of witnesses are allowed. In Chapter 21, Article 60, it's not. So if you were to bifurcate, it will entail, although I would anticipate that there would be some overlap with the facts and evidence to be presented, but we would still be dealing with two sets of procedures. Staff, at this point, I would reiterate that CDD staff has put forth for your board's consideration a recommendation finding that Justin Smith and Melissa Smith are not responsible persons for purposes of the high severity violations of Chapter 13. That would forego the need for having presentation of evidence under the set of procedures under Chapter 13. That entails cross-examination of witnesses and a number of other things. And that would leave your board with just the revocation of the permit issue.
And that would be my request. It's much cleaner, I think, for everybody to manage that. If that's what staff's recommendation is to grant in part now. My request is to do that, then we'll have a clean hearing on the remaining issues.
Thank you. Thank you for that request. County Council, I know that you are trying to do the wall of separation. I just want to make sure that somebody is available to ensure that the process is completely understood, so that when we come back, there is no confusion from any of all sides coming up for testimony or for arguments. So if we can make sure that that is made available so that we can get there. I'm going to go back to the board, and Supervisor Green, I'm looking for way forward at this moment in time.
I'm inclined to grant council's request to bifurcate the issue as far as the deeming the parties in this appeal as responsible persons. We've been down that road with the two prior appeals that have already been decided. I don't see anything in the factual attachment of this is going to change that particular examination. And in terms of both the economy for council and the appellants and ourselves, being able to come back on the 17th and focus solely on the issue of the proposed revocation, I think will be cleaner and shorter and not happier necessarily, but there's plenty to dig into there, and he does need some certainty of the procedures to be used, as do our staff. So,
sounds like you're leaning towards a motion here.
Well, you're just taking a poll at this point. So if you want to keep polling, you can. If not, I would turn to County Council for the form of the motion. If there's a form of a motion, I think it is, if I understood the little cheat sheet I had here, and county council can add on to this. But the motion would be to grant in part appeal AB 23-03 of the Planning Commission's decision determining Justin Smith and Melissa Smith as responsible persons for high-severity violations, and to somehow partially populate the findings of fact that would come from that. And I don't know if there'd be a second motion to continue the rest of the appeal to a date and time certain, September 17th. If you want a fixed time, I guess we need to turn to clerk for that. Do we have a time?
County Council, please help correct the original motion.
So in scheme of things, there would be two separate motions. One is what I would, at this point, characterize as an intended decision by your board, because as it was covered in the prior discussions of the prior appeals, typically your board then gets presented with all of the evidence, and your board issues at the conclusion of all presentation of evidence with an intended decision, whether to grant or deny, or grant in part or deny in part. And then you have that 45-day period kicks in, wherein staff is then directed to file a draft findings of fact for your board's consideration. So with all that being said, the first motion, with your board's approval, would be to approve an intended decision that Justin Smith and Melissa Smith are not responsible persons for the high-severity violations on property 2290 Soda Bay Road, APN 008-010-29, pursuant under the definition stated in the Lake County Code section 13-47Q, and direct staff to incorporate that intended decision in its findings of fact after the conclusion of this appeal hearing. That would be the motion.
And I apologize, I don't believe there is an
No.
intended.
Hold on.
I'm sorry, Mr. Chair, but, so about as confusing as today can be, but I am going to second the motion, because I do think the clearer path forward is this direction. We'll see what the board votes. But I'm going to second.
Thanks for the second.
I'm gonna
I'll say
second.
so moved so that he can second again.
Second.
All right, we have a motion and a second. All in favor? Aye. Any opposed? Motion carries. And looking for a second motion for September 17th at 11 a.m.
May I please be heard? I'm sorry, the issue of it being a tentative and intended decision.
So I think at this point, please speak with county council. There is no way for us to make a final decision on a piece of a appeal when the appeal as a whole has not been finalized. So please speak with county council to better understand the reasons behind that.
Yeah. Thank you.
So the second motion would be to continue the appeal hearing of appeal AB 23-03 to a date and time certain, and that would be September
17th at 11 a.m.
17 at 11 a.m.
So moved.
Second.
We have a motion and a second. All in favor?
Aye.
Any opposed? Motion carries. Thank you, and we will see you again on September 17th, and please make sure to reach out to county council.
Thank you. May I please have one more moment, please, about...
On the side, at this moment in time, this item is closed. We are done. We are available to speak with you afterwards.
I just want to make sure that I can talk to county council. I tried so much.
We just gave direction. Please do so.
Okay. That happened last time, and David didn't call me back.
Please do so.
Okay.
Okay, I believe we are on
6.11.
calendars, or?
6.11.
Oh, my
7
goodness
point something. We
gracious.
got one more.
Oh. Doug. Excuse me, 6:11, 3 p.m., sitting as the Lake County Air Quality Management District Board of Directors, notification of office closure and reduction of services. Mr. Gearhart. Good afternoon.
It's afternoon, so thank you.
We're not in the evening quite yet.
That's not evening. Positive.
So, okay. I assume you've received my memo that explains the situation. Brief summary is we're losing our engineer and going to very short staffing. Oh,
The public needs to hear you.
okay. Is that better?
Lean in.
Okay, I feel like I'm eating the mic, so. So we are losing our engineer. He's leaving next week, and so we will be down to 2 long-term staff and 1 brand-new hire. And we have, other than myself, no technical staff available at the district at this point. So we've done multiple recruitments this year and have had no luck in finding a quality or reliable applicant. Once we had 2 applicants the first time, 1 didn't accept, the other didn't work out and had to be let go fairly quickly. The second round of applicants, we had 1 applicant and they were not qualified for the position. So, so we've run into a lot of problems with recruitment recently, and this is the first time we've run into this problem where we haven't been able to find someone, and so we have a transition to, keep going, because we do, as you know, every department loses staff on a regular basis with turnover and things. So, so what we're doing now is we're trying to prioritize the immediate needs, the immediate issues and mandates that we have, and putting those into a notification so that the public's aware and you're aware that what the issues are and what we're doing to try and solve those. Our immediate issue is we have to maintain our attainment status, which means air monitoring. So we have no field staff at the moment. So that is myself and Elizabeth doing all the air monitoring. So we're kind of back to the old days when we started 20 years ago. And that will probably be 50 to 60%, maybe even higher percent of our time, just maintaining that equipment and all the QA and data processing that's required for that. So, so with that, then we have our permits, burn program, and those types of things that are essential mandatory functions. All non-mandatory functions are what we're proposing to basically put on hold. Grant programs are the, we like grant programs, but those are the lowest priority in terms of our mandates. And so we'll try and keep as many of them as we can, but they will be basically on hold. And if we can get back to them before the money has to be returned to the state, then we will. But if we can't, then there will be funds that get returned to the state as those programs come up for either expenditure or return. So we're hoping we can get this turned around fairly quickly, but it's whatever the market is on an application process. I have no guarantee, and we don't know where we're going yet. So, so with that, we're trying to keep everything that's essential and necessary. The prescribed burn program, of course, is a high priority. The reference in our memo to prescribe burn is regarding the grant program and the MOU with the state to do additional reporting that they're requesting. So that is going to be put on hold, but the burn permits system and stuff is being worked on right now. We're just waiting on contracts to be reviewed so we can get them signed and get the process and online system up and running. So with that, I guess I'll leave it. If you have more questions or need more details on specific things, I'm happy to help.
And just, I know it's in the memo, but just for the public who may not have had the chance to read the memo, you will be available via phone, via email. It's the office itself that will not be open to walk-ins.
Right, yeah, especially this time of year, we have very little walk-in traffic, so it's much easier to be able to do that, but we need people to call ahead and make an appointment. So the obvious reason is we're not always going to be available, and if people come in and all they can do is walk in the office and stand there and ding the bell and no one's there to help them, they get kind of angry, and we would much rather they call ahead. We can schedule a time when we know someone's going to be available that can help them through whatever process they need. We will be putting out some information and posting information on our website to explain for the different things that people do walk in for, like sign-offs with the county for building permits and things where they have generators or stuff that may need permitting. We'll put out some information that explains what to bring or what to send us so we can review it, and so when they come in, we've had that chance to look at it, and we can do their paperwork quickly and easily. So we are working on putting some of that together quickly. It won't be the prettiest information sheet, but it will be helpful, and we'll get people moved through the process as fast as we can. But calling ahead and making sure that we're available, and then making sure that application packets or details are complete will expedite the process for the public and for anyone needing things that are not standard permitting with us. So standard permitting, it's pretty straightforward, but anything else, it's just helpful to have complete information.
Okay, thank you very much. Supervisor Pyska.
And we're getting very close to burn permit season, and that's all going to be online. Is that correct?
Yeah, the online system is being worked on. We have contracts under review with county council, and just to make, so we can get everything formalized for this burn season. We hope to have those probably in the next week or so, and then we'll be getting the system up and running and tested well before burn season starts.
Okay, good.
So.
And then, for the prescribed fire, just again, because we've got some folks in the room here.
Yeah.
It's the extra monitoring that you won't be able to handle? Is that correct?
It's the prescribed fire grant and reporting that the state is requesting or demanding of us. So we have an MOU, and they can provide funding to do extra work, and those are the things that we're not going to be able to do. We still will have prescribed fire permits, and we'll still work with people on forecasting and doing all of the normal things of the burn program. It's just those extras that are under the state Air Resources Board programs that we won't be able to do for this season. So we can have the state, we can provide the raw data to them, and they can put together their report, but we won't be able to do that for them. So.
Okay. And then, are you still working for Mendocino County?
Yes. Yeah, I'm still working for Mendocino County, and that is an additional 10 hours a week, or up to an additional 10 hours a week over the 40-hour week here. So under the MOU, I'm still working 50 hours a week as a standard.
I believe that's done at the end of the year?
The end of the fiscal year.
We don't have an early termination on that.
It is possible to do an early termination with notice and things, but I will say the workload has decreased significantly. So my time most weeks is 2 to 5 hours, but with an occasional longer week when they have a special meeting or something that they need me to attend, but that's pretty rare now. So it's mostly about training and referring people to the right health and safety codes. Go read this and figure out what that means, and then I can help you through jump through those hoops.
While I appreciate that,
Yeah.
that you think that it sounds like it's low impact for you, but for cutting back services for Lake County residents, it's really hard to justify having your time also dedicated to a different county.
All right. Well, that's, I understand, and I'm still working my full time here, plus the extra time to do that program, so it's, a challenge either way. So, and then if things go bad there, we're still impacted with additional work if something goes wrong. So, so that's where weighing of all those issues is challenging.
So I believe that you, at least based on the memo, you're working on some contracts to see what can help out a little bit. And I also believe that you will be coming back to the board with some ideas and suggestions. So I appreciate that you're working on whatever plan that might be, whether that's Plan B, Plan C. You're obviously not giving up to fix this issue, and I appreciate that. I do hear that training in Lake County actually works to really help the people from Mendocino if you bring them here to do the work that we need to get accomplished. But it's unfortunate, and I hope that you're being open to different HR options on making the positions more accessible. Granted, you need to have a certain level of expertise to be able to fill those positions, but just being flexible and being open to different suggestions and ideas so that we can get you the help that you need. I don't disagree with the comments made by Supervisor Pyska. I know that's something that I have been worried about since the very beginning. Luckily, this is more towards the tail end rather than the beginning of it that we're seeing this problem. But at the same time, I don't want to say work over here, and by the way, you're on salary, you don't get paid, work more hours while you're getting paid for the extra hours of working at Mendocino. So it's kind of a, it's a selfish feeling to want you to stay here and do more, but as long as those hours stay that low, I think that it's going in the right direction. But anyone else have any, please?
I was just going to say, a lot of the things that I'm doing now with them also are co-benefits. So I'm doing, a lot, some of it's the state meetings and things where it's all, I can do it all remote, but I'm representing Lake and Mendocino County at the same time in those meetings. So I'm still doing the work for Mendocino, billing the time, but I'm also we're providing a benefit to both at the same time and splitting the time. So there's a lot of things that are a shared or educational experience to better and be more efficient here that I'm finding while I do things for them as well, so.
Okay. Again, staying on that topic, you said it's done at the end of the fiscal year, so we're talking June 30th, 2025?
Yes.
I don't know if there's consensus or not, but in case this takes longer than necessary, can we see that at the halfway point for a review so that the board can kind of get a better understanding of what's changed in your current office and what's the workload still for Mendocino, just so that we don't just let it slide and continue on all the way to June when there's a struggle currently and we need to make sure that people have access to the permits. We're keeping up on our attainment stuff. There's a lot of important things going on in your department, and so just to check in.
Yeah, I will definitely say with the recruitment issues and staffing issues, we'll be definitely giving you updates at least every couple months with the current status if we're still having ongoing issues. So we'll definitely bring it back.
I think I saw nods of yes for that.
Yeah.
Okay. Any other comments or questions? Let's open it up for public comment. Anyone wish to speak on this item? I see Frank's iPhone 2. Oh, so sorry. I did not see you get up.
So I had to hit, can you hear me?
We can hear you.
Oh, sorry, I had to hit like 6 buttons to unmute for some reason. Thank you for the opportunity. Frank Abel with the U.S. Forest Service in Upper Lake. And Doug, totally understand issues with staffing and multiple jobs working for multiple counties. I'm doing the same myself and having a lot of struggle. It did sound like there's not going to be a real severe impact to prescribed fire programs in the county, whether it be agency or agriculture or otherwise. Is that correct?
Yes, that's correct. We're doing our best to avoid any impacts. The only impact that may occur is weekend calls. We may be more stringent about requesting the call on Friday so we have time to forecast and do things, because it will be very limited availability on the weekends, which will probably be me doing all the burn calls for every weekend until we have staff hired and trained. So
I get it. Thanks, Doug. Appreciate all your work.
Thank you for the comment. Back to the chamber.
Yep, Paul Duncan, Operations Chief for CAL FIRE Northern Region. And I appreciate all of Doug's work. I'm just concerned anytime we have a reduction in service, especially coming into burn permit season and closing of the office when we've moved burn permits to that location, because we always have folks that come in that can't run a computer or turn an iPad on. So I just want to make sure we're kind of providing those folks a means of getting the permit by, I don't know if that's a kiosk somewhere that the folks can go up to and get a permit at, but just want to make sure that that's not impacting folks trying to get permits. I do not want to be an impediment to anybody doing any kind of burning in the county that's legal, because we do need to reduce our fuel loading, and we can't do it on the fire side by ourselves, so we need the help of landowners, property owners to do that correctly. And then as far as Doug and his position, is there a way that the county can incentivize him staying here locally? I understand he's on a salary, but is there a way we pay him on the weekends, or is there an additional pay that could be incentivized where he doesn't have to go out of the county and seek other employment for funding? Thank you.
Thank you very much. And I'll say I don't know that he was seeking employment other than being a great team player by Mendocino not being able to find a director for their air district for multiple
over 2 years they were searching, so yeah.
And so that's appreciated, especially if I remember correctly, your statements were that their lack of an air district leadership has impact on our air district. Very thoughtful of you, and thank you for your efforts on that. Please.
Good afternoon. My name is Lindsay Daly, Executive Director of the Tribal Eco Restoration Alliance. We're a community-based program here in Lake County. Have the honor of collaborating with a lot of great organizations throughout the county and agencies as well to put good fire on the ground. So we're very concerned when we got the memo, and I feel grateful just to hear the update from Doug and the prioritization of continuing prescribed burning and permitting as part of the essential and mandatory duties of air quality. Just lots of good work to do this season, so appreciate the support continuing, making sure that we're able to get permits and keep doing the good work. That's all. Thank you.
Thank you for your comment, and thank you for everything you do in our communities. Anybody else wish to speak on this item? I see no one in the Zoom room and no one getting up in the chamber. I'll bring it back to the board. Supervisor Pyska?
Just following up on Chief Duncan's comments, so folks that need help with online permitting, will they make an appointment, or we do have non-tech users?
Right. We have in previous years done appointments for those that need help, because we do recommend, or for the last 3 years, I think we've recommended appointments. And even with COVID, we were accepting appointments during that time as well. So we were making appointments to ensure that someone's available to help them and can do it timely and appropriately for them. So yeah, we just request people call, and we can set up an appointment if they're unable to do the online system, because that's been an ongoing issue for a number of years, and most of them do show up to our office to get those permits. So yeah, we're used to it, and we have a few months, hopefully, to work out all the details before burn season starts. So we will be working on refining that process to make sure we have an expedited process to help them through.
One quick comment, and this was also kind of based on Chief Duncan's comments. I know that Supervisor Simon has spoken highly of the kiosk that was set up in our child welfare office.
Yeah.
And if there's something that can be set up so that those that do go to the office, they can still have a simple access to be able to at least register or submit something. That would be, I think, technology, even though some people are technology adverse.
Right.
I think technology can play a role in helping out in this situation. So whatever is possible, please bring to our attention to see if you need our approval or our support. But I think that we got to look at all options.
Right. I was just going to say, our plan for this year is for anyone coming to the office will be to do their permit through the online system, but they'll be able to pay locally. Because I would say the vast majority of people that come in to do a permit in person, it's because they don't want to do the online payment system. So we're working on that so we can do the online system, and whether that's we enter it or we have an iPad or something out on the counter that we can allow them to enter all their information and then do it that way. That is what we're thinking at the moment. So
maybe a Venmo account might help. Supervisor Simon?
Yeah. Appreciate the update, obviously, with all the, good fire we're putting on the ground in the county here. I don't think we have a 4 or 5 months. I know last year there were some burns that happened in September, October last year, so it's coming up very quickly, and I know some of those are planned a year ahead and those types of things, but just want to get that out there, that I don't think we have 4 months. I think it's going to come a little bit quicker than that. The other thing is looking forward to any changes or suggestions you'll have as far as contracting. I know that's a challenge to get those engineers, not only in your department, but in many other departments, and some changes hopefully will be coming to the board to help us fill those positions. But looking at contracting opportunities with local agencies, tribes, something, I don't know, just so we have a backup plan if we're losing engineers or other folks, so we can continue moving in the direction to just help support you. So anything you bring to the board, I guess is what I'm saying, open to have those conversations, even if we've never done it before in Lake County, because sometimes you got to think outside of the box on how to do these things. So just want to give you my support for that, Doug.
Okay.
I imagine the rest of the board is the
Anything
same
you can
way.
bring scientific engineering into the county would be greatly appreciated. Air quality engineering is a unique side of engineering, so it encompasses a lot of different fields, so it's not a specialty. It's more of a general everything engineering, because you have to look at everything from civil to mechanical to chemical, all in one. So it's one of those odd ones where it's hard to find people. So getting people of scientific or engineering backgrounds is interested in moving to Lake County or working, being involved in Lake County is a key thing for us.
Well, how staffed up is Mendocino?
What's that?
Yeah.
Well, the Mendocino engineer used to work for us, so. And we're looking at contracting him to do some additional help with us for the moment, so.
Well, that's going the wrong way.
Yeah. Well, at least we're making,
Appreciate the item. Hope we can resolve this so that it doesn't have to last for too long. And please keep us posted. Again, I think we basically all shared, we want to support whatever new ideas you might have to be able to make this as palatable for everybody in the community so that we can continue to do the work that we're doing. And this is informational only, no action to take, and I don't think we have any further comments at this moment in time. So thank you very much for making this public announcement, and we'll look forward to seeing the announcement on the website, social media, and things like that so that everybody could be aware of how it is that they can continue to interact with your department.
okay, great. Well, thank you very much.
Thank you. And last is our calendars. Start with Supervisor Green.
Oh, my goodness. Met with Scotts Valley Community Advisory Council yesterday. Good discussion, actually really hitting the ground running and having some good substantive discussions. Tomorrow, I'll be having coffee with Supervisor-elect Rasmussen. We're going to be starting that up on a regular basis, just so we can touch base. Looks like First Five Commission that afternoon. Fair's coming up, so it looks like I'm going to the Blue Ribbon Dinner on Thursday. Above and beyond that, with Labor Day coming up, the calendar's pretty clear, and if it wasn't clear, I'd be clearing it just because I had a little car incident over the weekend, so I'm going to be, if you see me around town hoofing, you'll know why. But that's about all I have for now.
That's the Blue Zone's way. Next is Supervisor Simon.
Yeah, same with mine, pretty, pretty clear agenda here. We've got the holiday coming up this weekend. Definitely will make it out to the fair. Obviously, 4-H will be doing their thing, which they do every year, which go out and support the kids. I know all the businesses show up, and, hopefully they all get to sell everything that they've raised. So anyway, I wish everybody good luck this weekend. And then next week, I have the Geothermal Advisory Committee on my schedule on the 5th. And then on, looks like Friday the 6th, I also have State Board of Fire Services, and then back here on the 10th for the meeting.
Vice Chair Pyska?
Well, I just first want to give an announcement. The Blackberry Cobbler Festival was massive. I think there was about 4,500, 5,000 people that came. Calpine and Sutter were both the platinum sponsors this year, so two really wonderful organizations that always give back and always support our communities. So thanks to all the volunteers who helped to make that happen. It's a really big deal for the community to have that many people showing up and coming and supporting all the other local businesses. And tomorrow I have the CSAC visit. Oh, that's at 8:30. Change that. And then after that, the webinar panel with Insurance Commissioner Lara. And then Thursday, I have a PG&E check-in meeting, a wood storage meeting. We're going to be meeting in Upper Lake.
That's right.
And the rec agency meeting got no quorum, so I'm going to decline that one. And then I will also be at the Blue Ribbon Dinner. And then Friday, I have an insurance working group meeting. I will be at the football game Friday night. Fair Saturday morning for the auction. And let's see, next Tuesday, I have NCO governing board meeting since we won't be here in Ukiah. And then I have meeting with CDD on the 5th, then later in that, on that afternoon, the geothermal meeting, and then my meeting with CAO Parker on the 9th.
Thank you. Vice Chair Crandall?
So tonight, 6 PM at the Clear Lake Oaks Moose Lodge. John T. Klaus, there'll be a meeting and something like a town hall or something of the like there. I will be going to the meeting Thursday in Upper Lake with Supervisor Pyska. I won't be going to the Blue Ribbon dinner. I was thinking about it, but I realized it's my son's birthday, so I'll have to take him out to dinner or something like that. And then Friday, I will be, I have an open calendar, but I know that I'm going to be going to a dinner for one of my nephews who's going off to the Navy. Lalo Perez from Upper Lake just graduated. He's going to the Navy. It's always good when a kid's going off for a while to explore the world and become a veteran and serve their country. So as for that, I know that we have something on the 9th, PG&E, right? And then I know CERT will be that night, and back here on the 10th for our Board of Supervisors meeting.
Thank you very much. So tomorrow, doing a quick update with LG Sonic early in the morning, meeting with our CSAC president and 2 staff members from CSAC. Really appreciate the help from the CAO's office in helping organize all of that. And thankful for the supervisors that are involved as well in presenting. Later on, because I believe it should be done by about 1:30, I do plan on going to the First Five Commission as well to keep track of what's going on there, and then we'll finish the day off with joining the Lake County Fire Protection District board meeting. On Thursday, I'll be taking off to the CSAC Board of Directors meeting in Sacramento. There's going to be a lot of voting of what propositions to support, things like that. That is the last meeting before the election where we really want to get that out there about CSAC support or not support. And just to let you know, and maybe I need to do this differently in the future, I don't bring things to the board saying, how do you want me to vote at CSAC? But just know that I try to find what I feel the board would say rather than just my own personal opinion on certain propositions, because I'm there to represent Lake County. I'm not there to represent myself as an individual. So even though I know I may vote one way personally, I make sure to vote the way that I think Lake County would need and want to vote. And so let me know if I need to change the way that I do that. Later on, I should be able to come back in time for the Continuum of Care. The Interfaith Committee is meeting. We're continuously trying to engage with our faith leadership throughout the county and better understanding how the COC and that leadership can come together to better help those in need. On Friday morning, pit count discussion will be happening at the courthouse. And also I will be involved in a conversation with our auditor for our finances for the County of Lake. I will not be at the fair because I will be visiting my family since it is a birthday that I will be celebrating. So I hope it goes well. And my following week is fairly vacant other than we do have a COC meeting that Thursday. The City Council for the City of Clear Lake will be happening later on that evening. And then I believe that we're both involved in this, Vice Chair Crandall, but the EEL Visioning Workshop that's happening at Robinson Rancheria on the 6th. Okay. And then coming back on the 9th, as stated, meeting with PG&E and meeting with our CAO to prepare for Tuesday. And I'm, no offense, I'd have appreciated Mr. Carter's presence in our conversations, but I'm really hopeful that we get to meet with CAO Parker on next Monday. Her presence is missed. And then back here for our meeting on Tuesday. And with that, you got a do-over?
I really do, but you reminded me, because the Clear Lake, I wanted to give a shout out to Clear Lake City Manager Alan Flora and his lovely wife Nicole for being kind enough to stop on Highway 20 as my stupid car was breaking down and check up on me and give me a ride down to Cal Fire Station, which was not staffed, and then gave me a ride back to my car, and then gave my poor sister, who was trapped, a ride home to Lakeport while I got the car in AAA squared away. I have never been so happy to see a random car stop after a long uphill trek to nowhere than I was to see them, and it's just such a random encounter, but random acts of kindness such as Mr. and Mrs. Flora bestowed on me. I'm very grateful.
Lots of good people in the area. All right, thank you for that. And with that, we're going to go into closed session. 8.1, conference with legal counsel, decision whether to initiate litigation pursuant to Government Code Section 54956.9D4, one potential case. And with that, our open session is complete and our meeting is adjourned. Thank you. It's adjourned to closed session.